Please be seated. All right. Morning, ladies and gentlemen. We're here in regards to Commonwealth versus Shawn Mickey Stines, 24 CR 204. If Mr. Steele, if you would identify the Commonwealth and who's here on behalf of the
Judge,
Commonwealth.
I would. Defense counsel is not here in order to apply.
All right, let's get them out here, please.
In the meantime, Your Honor, Jackie Steele, assistant or Commonwealth attorney, 27th Circuit Special Prosecutor's Panel.
Ramsey Dowell, Assistant Attorney General, Special Prosecutor on behalf of the Commonwealth, Your Honor.
Thank you.
Your Honor, while we're waiting on Sheriff Stines and his counsel, I just thought I'd introduce myself. My name is Chris Reinhardt. I represent Kimberly Mullins as administratrix of the estate of Kevin Mullins, as well as her personally introduced. Thank you, Your Honor. And that's it.
All right, thank you.
I'll go on you.
All right, Mr. Bartlett, if you identify yourself and who's the counsel table with you for the record.
Mr. Sharp, I have just 1 second on the local box, sir. Mr. Sharp, Jeremy Bartley on behalf of Mr. Stines, also co-counsel Ms. Carrie Bartley, as well as co-counsel Mr. Jim Cox. Your Honor, there's members of my staff, but they're intended to seat in the gallery and not
Sure.
otherwise at the table.
That'll be fine. All right,
Can we seat it, Your Honor?
please.
Thank you.
All right, since we last met, we've got some motions that are still outstanding. We want to try and address some of these, and start looking at heading towards, hopefully getting this matter set for trial. First, there's a pending motion for a hearing pursuant to KRS 532.135 to exclude the death penalty at trial. The Commonwealth has filed no notice of aggravated circumstances up to this point. My understanding, after briefly speaking to the parties and chambers, is that we're gonna hold that motion in abeyance, pending the resolution of any other potential evaluations, and then if the Commonwealth files notice, readdress that. Is that correct, Mr. Bartley?
That's correct, Your Honor, with the caveat that we discussed, that obviously would be in ample time so that it wouldn't affect trial strategy.
Absolutely.
Or any, if there's any additional experts as a result, such as mitigation, Your Honor.
Absolutely. And that'll be set pursuant to the rules. Next, the Commonwealth's given notice regarding a criminal responsibility examination. Mr. Steele, do you want to address that?
Your Honor, Ms. Ramsey will address that issue.
Your Honor, the Commonwealth, as the court noted, has filed a notice requesting a second mental health evaluation to be conducted by a private expert retained by the Commonwealth, Your Honor. It's our position that the Commonwealth is entitled to that. The defendant has filed notice pursuant to Rules of Criminal Procedure 8.07, subsections 1B and 2B, and accordingly the Commonwealth is entitled to rebut any defense related to insanity or any evidence going to issues of guilt or punishment related to mental disease or defect. So it's the Commonwealth's position that we are entitled to a second evaluation. We're not requesting funds from the court, Your Honor, for that to be done by our private expert and for Mr. Stines to submit to that evaluation, Your Honor.
All right. And I've read the pleadings in regards to that. Mr. Bartley?
Mr. Honor, the criminal rules, I think, are pretty clear that in fact we have to give notice in terms of our intention to introduce the defense of insanity. I hate that nomenclature, but it still persists, so I will use that for purposes of today's hearing. However, we've given that notice. We gave that almost as soon as we got into the case. And we identified Dr. Drogan as our intended expert. At this At this point, he's not completed, or will comply with the rules in terms of doing so. But the rules of criminal procedure that were cited in the notice, I believe, are 807. And under that rule, Your Honor, I agree that they are entitled to have Mr. Stines evaluated, and that's why they filed the first notice and they asked for the court to send the KCPC. They could have gotten any expert they want at the beginning. I mean, like they said, they've got the money. They can send them wherever they want to go. KCPC is the Commonwealth's, as they've always made very clear, that is their facility. And they availed themselves of that facility. And he waived his Fifth Amendment right as to an examination. It's a quid pro quo. If you put mental health at issue, then I believe that the Commonwealth has a right to have him examined. And he's done that. And I look in reference, Your Honor, to KRS 504, the section cited in my in the civil rule, as well as in RCR it's 807, Your Honor. It says that they're entitled to an evaluation, Your Honor. And I believe under the rules of statutory interpretation, the first thing you look at is plain language. To me, "and" signifies, and 504 is adopted by reference into the criminal rule that's cited for the notice, Your Honor. And I believe that "and" in its ordinary meaning means singular. And I think the concern is multiple. First of all, if you look at the case that I cited there, it is Benjamin v. Commonwealth, 266 Southwest 3rd, 775. And in that case, they were looking at a defense request for another evaluation, and they said basically, if you don't like the result, that's tough. And it's an even playing field I would urge the court to hold here now. Again, if you file notice of insanity, I think there is a limited waiver of your Fifth Amendment rights, but the cases make it very clear it's limited. It's limited in scope, and the statutes address what should and should not be brought in. But the remedy, if he were not to have complied with the first examination, would have been that the court could do anything up into striking his entire defense. But in this instance, Your Honor, we willingly, readily presented him to their expert. That was their expert that they asked him to see. And now what they're asking the court to do is make him go to another. Now, what I suggested in my response was that they could very well, do I believe they can hire another expert and pay them to come in and testify? Yes. I don't think there's anything I can do to stop that. It's the evaluation that I think is the invasive part, Your Honor, that would subject him to yet another waiver of his Fifth Amendment. We are now 2 years out. You know, the first evaluation will be much more relevant. But if they want to get there and get another opinion and have somebody come in and say, Drogan and Dr. Allen, there's reasons not to believe that testimony, I can't refer to it, Judge, but that testimony that the court's aware of, then I think they can. And they can get there by simply having them review the procedures by KCPC. They have all the data. They have all the data that is there. And they can provide that to an expert. He can look at that and he can opine that the previous opinion is incorrect, or impeach it, Judge. I'm trying very hard not to breach the reference, Your Honor. But I think that that's it. In the civil context, there has to be, you're looking at, is there something flawed in this examination? I mean, I think if their motion said, when we see in the KCPC, they rushed and did it, and it was incomplete, it was this and that, they've had the evaluation, and we agreed that they could share that with whoever they potentially want to look at it. Then I would say today, if there was some evidence they could put on for the court that this was flawed, of course we would cross that and ask to subject it to proof. But I believe that's what they should have to do, rather than just have him again waive his Fifth Amendment right, go to a state expert again. He was compelled to do it from the jail twice. He was compelled to do it at KCPC, Your Honor. And I think that, you know, my question also becomes is, where does that stop? I mean, at some point, how many examinations do we send him to? If this is if this expert, whoever he may be, were to agree with both our expert and Dr. Allen from KCPC, do we get another one? And I think that's exactly why the courts have said that the waiver of the Fifth Amendment in this context should be limited, Your Honor. And I would ask the court to find that he did his part. He understood the quid pro quo. We discussed that on the front end, but what we didn't discuss was a quid pro double quo, Your Honor. And so I'm asking the court they can still get their expert to rebut. I understand there are cases that talk about they get an opportunity to rebut it, but there's nothing that should compel him to once again waive the Fifth Amendment right and go see an expert that the government mandates, Your Honor. They can get to the same point without compromising that yet again, Your Honor.
All right, Ms. Dahlman, respond.
Yes, Your Honor. The Commonwealth's position is that it's clear here, there is no statute, rule of criminal procedure, or case law that would serve as precedence for this court saying that the Commonwealth is limited to a single evaluation of the defendant as to criminal responsibility. There is nothing out there that says that. Instead, the Commonwealth has the burden of rebutting the offenses that the defendant has indicated he intends to present. The Commonwealth's position is that the reliance on the Benjamin versus Commonwealth case is completely misplaced. That was a very different situation. In Benjamin, there was a defendant who was asserting both competency issues as well as criminal responsibility. In that case, an evaluation had already been conducted. The defendant had not until the day that trial began articulated specific reasons for a request for funds for an additional evaluation. At that time, the court said, no, your request isn't timely, it's not necessary, and then an appellate court in reviewing that said, due process was not violated, Your Honor. This is markedly different. We're not here asking the court for funds. We're certainly not requesting a second evaluation the day that trial begins. We don't even have a trial date at this point, Your Honor. So the Commonwealth feels that our request is valid and that a second evaluation should be conducted of the defendant. Additionally, the experts at KCPC, I believe the defense has referred to as the state's expert. Well, Your Honor, if the Commonwealth is not conceding that the defense can call an expert from KCPC who evaluated the defendant at trial as their expert, but if they intend to do so, then certainly that expert would not serve as the Commonwealth's expert, and therefore we would be entitled to obtain a private expert to evaluate the defendant in this case. As far as any waiver of Fifth Amendment concerns, that is explicitly addressed in the rules of criminal procedure, specifically under 8.06 and 8.07. It says that any statements made by the defendant in the course of these examinations cannot be used against the defendant unless they choose to use those examinations and evaluations to their benefit. So that is addressed directly in the statute. That argument is completely without merit. So we would ask that the Commonwealth be allowed to have their private expert conduct an evaluation of the defendant.
All right. Ms. Martin, respond.
Yes, sir. That's completely the inverse. I agree. There's nothing out there that says they can't, but there's nothing out there that says they can't. And so my point is this, Judge. I mean, so it should be limited to the intention of the rule. The intention of the rule is to give a fair play. He waived that right. It should be limited, Your Honor, in terms of whether the statements are privileged. That blanket prohibition of the statute is riddled with exceptions. And I'll be very surprised. I'll be extremely shocked if we get to a trial and there are not statements from any of the examinations that come in. It's riddled with exclusions, Your Honor. I ask the court not compel Mr. Stines to, once again, Judge, produce evidence that is potentially used against him, Your Honor. Again, you can accomplish both goals by letting them have the prior evaluation, the raw data from that examination, and they can still have someone to rebut them. As far as whose witness it is, they asked that the court order he see their expert. That was the first notice, and they said their expert was going to be at KCPC. Now they're asking for an independent expert. They were both Commonwealth's expert. The fact that I may call them is irrelevant. I mean, they weren't the court's. I didn't ask for it. So obviously it's their witness, Your Honor. So regardless of who calls them or whatever that may be, we didn't ask to see Dr. Allen, but we do want to hear what he has to say at trial, Your Honor.
All right. Ms. Dahl, if the court does order another evaluation pursuant to the Commonwealth's request, what kind of timeline are we looking at?
Your Honor, we don't foresee our expert having, he's located out of state in Indiana, but fairly nearby.
Okay.
Of course, there would be travel time and we would accommodate his schedule, but we're not expecting any significant delay, Your Honor.
Okay.
Your Honor, if I may,
Sure.
in terms of if the court does permit the second
Sure.
expert, Your Honor, then what we're asking is that, once again, Dr. Drogan be permitted, our
Absolutely.
original expert. But, Your Honor, I think it's very prudent, and it's not without precedent, actually, with Dr. Allen, that the KCPC doctor be there as well, because if they're going to rebut and be critical of what he did, Your Honor, then I think it is only fair that we should be able to have him observe so that he can respond to the criticisms that they place on the KCPC examiner.
Okay. All right.
Your Honor, if I may, the Commonwealth does not have any objection to Dr. Drogan appearing. We would have an objection to Dr. Allen.
If I do order it, I would have obviously no issue with Dr. Drogan being present. I am going to have to look at whether or not Dr. Allen being present would be appropriate in regards to it. I've not made a ruling yet in regards to another evaluation, but I do think the court inherently, under RCR 807 1B, has the authority to order the second evaluation, but I want to review the pleadings and I will get an order out to the parties shortly in regards to that, because I do want, timing-wise, if this is going to be done, to get that moving. So, next issue before the court.
Your Honor, can I have one more thing, Your Honor, in
Sure.
terms of that? If the court does in fact order that examination, then I believe that we're entitled to discovery as to fees paid, and as well as
Sure.
ours as well. I just
Sure,
want to make sure we
absolutely.
get that discovery as well.
That'd be no problem at all.
Thank you.
All right. Next, let's go ahead and, Mr. Bartley, you've got pending bond motion.
Your Honor, I'd ask that Ms. Bartley take that issue with court.
Ms. Bartley, go ahead.
Yes, Your Honor. Carrie Bartley on behalf of Mr. Stines. Judge, the court has issued an order basically granting us the evidentiary hearing that we requested. It's the Commonwealth's burden to put on proof that the defendant's guilt is, proof is evident, or the presumption is great of his guilt of a capital offense. We don't believe that they would be able to do that. Cases under Markham v. Broughton say that essentially where conflicting evidence creates a plausible basis for self-protection, which is not necessarily what we have here, or a reduction out of the capital range, that the Commonwealth can't meet that burden. And so, Judge, what we would ask is just for the court to hear the Commonwealth's proof, and then if necessary, then we have some brief proof that we would like to put on as well.
All right. Mr.
Judge, we discussed this previously, and Commonwealth is ready to proceed. We're going to submit to the court the recording of the shooting that day.
Okay.
It was played, it was introduced.
It's part of the record. I
It's
know.
part of the record, but we're going to submit it to you
All right.
for your consideration.
Go ahead.
And Your Honor, we would object to that. I believe it's, the Commonwealth has to put that on. The rules of evidence apply, the court has rules of evidence apply. We don't think that the Commonwealth can lay a foundation for that video today. I don't think they have a witness to testify to that today. And so I don't think that it's appropriate for the court to take it into consideration today if they can't put on any evidence as to.
All right, that objection to overruled. All right.
Judge, if I may just say on that issue, and I'll be very brief, this was introduced in the preliminary hearing. Foundation was laid. Same counsel was present during that, and no objection to it being
And Your Honor, at that point, if I may, the rules of evidence do not apply in a preliminary hearing. The rules of evidence do apply today under Young, the Young case. Judge, the court cited that in its own order. And so I would, again, vehemently object for the record to this being introduced without any foundation being laid at this particular hearing where the rules of evidence do apply. And, you know, Judge, I just don't think it's appropriate. I think that, you know, it sort of flies in the face of applying the rules of evidence, or for that being the court's ruling, that those rules apply, Judge, if we allow the Commonwealth to put in proof without having any testimony to that effect and without any witness being here to be subject to cross-examination as to that issue.
Well, just,
Judge, under Rule 1101, applicability of rules, it says, subsection D, rules and applicable to rules other than with respect to privileges do not apply in the following instances. Number 5, miscellaneous proceedings, without reading all those, it says, and proceedings with respect to release on bail or otherwise.
Yes, Your Honor, and again, I can reference to the court's bond order, where the court specifically references to the Young case, Judge, that says that the subject to the rules of evidence, Young v. Russell, upon request for bail, the defendant may testify, call witnesses, etc. So the rules of evidence absolutely apply. It's in the Young case. It's black letter law, Judge.
all right, the court's going to overrule the objection. The facts surrounding September 19th of 2024, which is the basis of this action, there is information in the record previously which transfers from the district court case pursuant to the indictment. I do believe that it would be appropriate for the court's consideration. So, anything else in regards to, anything else you want to review on bond?
Yes, Judge, I have a witness if I may call.
Absolutely.
Defense would call Ms. Sherry Stines.
All right, this time.
And Judge, if it's okay, I'd like to stay at council table. I think that there's an issue with the podium that
That'd be fine.
kind of goes up and down.
All right. Ma'am, you can stay right at the podium. All right. If you will, raise your right hand and be sworn. Do you swear from the testimony you give to be the truth, whole truth, nothing but the truth?
I do.
All right, ma'am, if you would state and spell your name for the record.
Sherry Stines. SherriStines.
All right, Ms. Bartley, may I ask?
Yes, Your Honor. Ms. Stines, again, Sherry, just tell us where you're from, where you live.
I'm from Neon, Kentucky.
Okay, is that in Letcher County?
Yes,
All right. Do you know Shawn Mickey Stines?
yes.
What do you call him?
I call him Bubby.
Bubby? Okay.
Yes, he's biologically my nephew, but my mother and father raised him.
Well, that was my next question. What's your relationship to him? So,
Yes.
you're his aunt, is
Yes.
that correct?
Yes,
All right. Now, how close of a relationship do you have with Mickey now?
very close.
And has it always been close?
Yes.
Okay. How much older than Mickey are you?
I'm 62. He's getting ready to be 45.
Did you ever live with Mickey?
Yes.
And is it okay with you if I call him Mickey? I know you call him Bubby.
Yeah, I
but
call
don't
him
think we're that
Mickey,
close
yeah.
yet, so he may not like that. I want to ask you about the date, September 18th of 2024. Do you recall the events of that day?
Yes, it's the day he stayed all night with me.
Okay. And you said that's the day he stayed all night with you. So you saw Mickey that day, is that
Yes, yes.
right? Okay. And about what time that day did you see Mickey?
It was late in the day when he came by the house. It wasn't dark, but you know, it was later in the day.
Okay. And when he showed up to your house, did you know he was going to stay the night with you?
Yes, he told
Was it common for Mickey to spend the night with you?
me. No.
Why was he going to stay the night with you that night?
I think it was going to be just to let his wife and daughter rest, where he had been such a nervous wreck and wasn't sleeping.
Okay.
You
So
know.
you said he was going to let his wife and daughter rest. Now tell me,
Yeah.
why couldn't they rest?
Because he couldn't sleep and he was wiping the floors, and I guess he was aggravating them, you know.
Okay. Now, did you talk to his wife or his daughter about that at all?
No, not that night. He was at the house, so I didn't. I tried not to get in that.
When he came to your house, had he called you before and said, I'm coming over?
I can't remember if he called and said he was coming or not, but he knew he could come anytime he wanted. It's like his second home.
Okay, so you said he came by later that evening.
Yeah.
And when he came by, did he bring anything with him?
He brought a bag, and in it he had those little tuna creations, and turned out it was like melatonin gummies and some over-the-counter Benadryl.
And did he have anything to say about why he had Benadryl or melatonin gummies?
Well, he hadn't been sleeping, and it's like he hadn't slept in 7 days and nights. And he had went to the doctor, and they had told him to take the Benadryl and the melatonin to help him rest.
When?
I'm assuming it was that day or the day before. It was very close.
So he had gone pretty close in time to when he
Yeah.
You don't know for sure the day?
Yeah, no.
Okay. And the doctor recommended to him to take melatonin and Benadryl to
Right.
try to get some sleep?
Over the counter.
Okay. And when he got to your house, what did y'all do first?
We just basically sit around, watch TV. I went in and I fixed us a little bit of supper. We ate. He didn't eat a lot.
What'd you make?
Pork chops, like green beans,
No,
potatoes.
I'm going to object this time. I don't understand the relevance as to what we're here for and upon in regards to that question.
I'm gonna overrule the objection that asked counsel.
Yes, Your Honor. So Mickey got to your house, you ate some dinner, and then what did you do? What happened?
Just sit around for a minute. He was real fidgety, walking from one door to the next. It kept getting later, and I take oxygen at night. So I sat in my recliner at night and take my oxygen. So I give him a bed in my house. I have an extra bedroom. Told him to go lay down. He goes in, he lays down for a few minutes, and then before I know it, he's right back in the living room with me, and he's carrying a pillow. And I said, "Baby, can't you sleep?" And, no, I just can't. And he would take like melatonin and Benadryl, sit there, keep his phone in his hand. And he was watching his security cameras, watching around his house.
So he was watching the security cameras at his house?
Around his house, yeah.
At his house, okay.
Yeah.
And you said, let me go back to the melatonin and Benadryl. So he was taking melatonin and Benadryl. Did he take that at the same time?
Yes.
Do you know what kind of Benadryl or melatonin it was? How many milligrams, anything like that?
I don't know, but I've still got them at home in the bag he had them in.
Okay. So about how many, if you had to guess, or if you know, don't guess, if you know, how many melatonin, how many Benadryl did Nikki take that night?
I'd say about 3 to 4 Benadryl and about the same with the melatonin gummies.
And did those seem to have any effect on him at all?
No.
And so did he sleep?
No.
You said he was on his phone looking at the security cameras,
Mhm.
and he was looking at the area around his house.
Yes.
Did he have concerns about what was going on around his house?
Oh, yeah, he was paranoid. He thought somebody was going to be around his house and, you know, like, I guess do something, bother something.
What was he concerned about in terms of someone being at his house?
He was worried about Lila and Caroline, his wife and daughter.
He's worried about his wife and daughter.
Yeah.
Did you say anything at all? Did you get any indication of why he would be worried about his wife and daughter?
No, but I knew he was under a lot of pressure, a lot of stress.
Did he mention that there had been any specific threats to him?
Nothing specific, but I just, you know, you could tell the way he acted, it was bad. He was horrified. He was scared to death.
He was scared to death.
Yeah.
You don't know what he was scared to death of?
No, but, you know, I had my theories, but
Well, let's not talk about theories.
that's my theories, but that's not what it was, you know, that I know.
Okay, so you said you were up all night with him,
Yes.
okay? And at any point, did he go anywhere?
No, but he did try to get me, the daughter my mother adopted a child, and at the time she'd been at the doctor's office, had a headache, passed out, done MRI, she was in the bed. Well, Mickey at one point tried to get me to ride up by his house just to check around his house and make sure it was all right, and he wanted me to leave her in the bed. Anybody that knows Mickey would have never suggested you leave a junior in high school in the bed by itself when it's dark outside, to go check around somebody's house.
He wanted you to go with him to check on his home.
Yes, his home.
Had there
Yeah.
been something that made him want to go out there?
There was a guy walking down the back street behind his house, and you could see his legs. And he was just walking down the alleyway, but it was enough to freak him out.
What did he think was going to happen, if you know?
Just my opinion, I think he thought they was gonna like circle around by his house.
And do what?
I don't know.
He said he was concerned about Caroline and Lila.
Mhm.
And what was it about Caroline and Lila? Did he mention anything specific to them, what he was afraid of?
He was just afraid somebody was gonna hurt him.
I heard him.
Yeah.
Now, you've known Mickey for a long time.
Mhm.
His whole life?
Yeah, he brought him home from the hospital.
You familiar with his normal behavior?
Yeah.
What's Mickey like normally?
He's a jokester. He likes to laugh, play. He helps people a lot. He's a good guy. Hyperactive. He goes out and does stuff without you having to beg him to do it, you know, or ask him. If he sees you need help, he'll help you.
Was his behavior that night consistent with his normal behavior?
No, no. He acted different. I've never seen Mickey act like that.
You had to describe how he acted in one word. What would you say?
One word, he was kind of psychotic.
Did he ever sleep?
No, while I was with him.
What time did he leave your house?
He left the next morning. Now, I didn't look at the clock, but it was between 8 and 9.
Between 8 and 9?
Yeah, something like that. But I didn't look at my clock, so, but it was early.
And at that point, had he slept at all?
No.
Okay. Did you talk to Mickey anymore after he left your house that day?
Yes.
And let me back up. Was that September 19th of 2024?
Yes.
Okay. You talked to him again after that?
Yes.
How many times?
I think he tried to call me once, a voice call, but then he did FaceTime me once from the courthouse.
From the courthouse?
Yeah.
About what time was that?
2:49 maybe?
2:49?
Yeah.
Okay. And that's PM, I assume.
Yeah, yeah.
If I showed you a screenshot from a video, and Judge, this is gonna be a screenshot from the video that the Commonwealth is introduced. If I showed you a screenshot of a video, do you believe that you could identify the person on the phone?
I'll try.
Judge, if I may approach you.
Sure.
Jackie.
Are you wanting to mark that for the record?
No, Your Honor, I'm just.
Okay.
I'm sorry, say that again now.
To me,
You believe that's you?
yes.
And is that roughly the time? Let's see, I'm gonna go here. Apologies. Judge, if I can approach again.
Sure.
I have a time-stamped screenshot, Your Honor, of the video. 1438 is, I'm sorry, 1448. And that's you on the video?
Yes.
Okay, and that's the FaceTime call that Mickey made to you?
Yes.
And is that about the correct time that you recall him FaceTiming
Yeah.
you? On that FaceTime call, what did Mickey say?
Well, like I said, my mother and daddy raised him, so he had a name for my mother. He called her Mommy Bones.
Mommy Bones?
Mommy Bones.
Okay.
And he called me and he said, Sherry, and I said, what? He said, let me speak to Bones. That's what he called Mommy.
Did you let him speak to Bones?
She'd been dead 2.5 years. And I said, what? And he said, let me speak to Bones. I said, Bubby, where you at? Are you at the office? He said, let me call you back. I got a bad connection. I said, well, okay, call me back. He said, love you, bye. And that's the last time I talked to him.
That's the last time you talked to him.
That's the last time I talked to him.
Did you find that call concerning?
Yes.
Well,
He asked for my mother twice. He was with me when I had to unhook my mother from the ventilator. So he knew she was gone. It was me and him together had to unplug it, so he knew she was gone.
again, has Mickey ever acted this way in the past?
No.
Did you eventually find out what happened at the courthouse that day?
Yes.
When did you find out?
It took about, till I found out for sure, about half an hour.
What was your reaction to that news?
My knees got kind of weak and my mouth fell open, and I cried my eyes out.
Is that something that you could ever imagine that Mickey would do?
Never in a million years would I have ever thought that Mickey would even discharge his gun, let alone do something like that.
Has he ever been violent?
No.
Has he ever been angry, mean, rageful, any of those things?
You know, everybody gets angry, but I've never seen him violent.
Yeah. Do you know if he's ever discharged his weapon?
Not that I know of.
Did you have an interview with the police after this all happened? And did you tell them that day what you're telling us today?
Yeah.
You said that you still have the Benadryl and the melatonin at your house.
Mhm.
The police come to your house?
No.
How'd you talk to them?
On the phone.
On the phone?
Yeah.
How many times did you talk to them?
Once was like an interview conversation, and then I think I may have had to call them back once after that because I remembered something. And they told me if I remembered anything to call them back, but I can't remember specifically what it was.
Okay, but they never came out to the house?
No,
They never collected any evidence?
no,
They didn't take the medication?
no.
You kept in touch with Mickey at all since he's been in jail?
Yeah, I wrote him a bunch at first, but now it's down to just like FaceTime, and I'll go up and FaceTime, you know, with his wife, daughter, something like that. Not as much as it was, but it's as much as I can.
Sure. You know how he's doing?
He's not doing good at all.
When you say that, what do you mean?
I mean, he's always had to take antibiotics every day of his life. He's got a really bad infection in his head. And it's not just looks-wise, it's painful, and it's getting on his face. His head's got these, it's hard to lay his head on pillows. He's in a lot of pain, is the point. This tick bite he got has always caused him a lot of trouble.
Tell me about that. You said he got a tick bite?
Yeah, they call it California encephalitis or something like that.
Do you know what that is?
He went to and from the hospital so much, and they kind of acted like it was a mystery illness, like, oh God, just, we can't find it, just go home and take Tylenol. But it just, his blood pressure would be up, it would be down, up, down, and it was, he just looked pitiful. You know, in that hospital bed, his feet hanging over him, them acting like he wasn't sick, and they come to find out, run the test, that it really was something.
And what was it again?
It was from a tick bite. I think they call it California encephalitis.
California encephalitis?
Yeah.
And do you have any idea, I know you're not a doctor, but aside from just being tired, being in and out of the doctor's office and things like that, do you know in any way how that affected Mickey, what symptoms he had, anything like that?
No, it had a lot to do with tightness in his head and stuff like that, I think.
Tightness in his head?
Yeah,
Okay. Did it have any behavioral symptoms?
I don't know.
No, no. Okay, and that's fair, that's fair.
But now he does have really high blood pressure. He was born with a heart murmur. And he's just always had a lot of health problems, chest-wise. You know, heart, lungs, he had a hard time breathing. And it seems to be his health going down.
Health's going down.
Yeah.
Has Mickey lived in Letcher County his whole life?
Yeah.
All right, born and raised. You brought him home from the hospital.
Yeah.
Right, do his wife and kids live in Letcher County?
Yes.
Alright. I think you already kinda told us when he was sheriff.
Mhm.
What kind of sheriff was he?
He tried his best to help everybody, if he could, to give everybody a chance. Tried to help turn their lives, he tried to help their families too. They were having a hard time with their kids, he tried to help.
Mickey got any criminal record?
Nope,
You know if Mickey has a passport?
no,
Has he ever been out of the country?
no,
Ever been on an airplane?
no, I'd have never heard the end of it if he had.
As far as you know, what's his relationship like with Caroline and Lila?
They seem to get along great. I mean, everybody has trouble,
Sure.
you know, but can't live with each other, can't live without each other, you know.
Now, if Mickey were to get out on bond, does he have a place to go?
Yes, always.
Where?
Me or them.
They still willing to take you in?
Why, yeah.
You willing to take him in?
Yeah.
Judge decides to give him a bond and he's able to make that bond. Do you think he'd comply with the bond condition?
Yes.
Would he show up for court?
Yes.
Would he take off and go to Mexico?
No.
Judge, if I can have just a moment.
Sure.
Oh. You said you had written Mickey some letters and things from jail. You ever FaceTime with him?
Yeah.
And do you do that just you and him?
I go up to his wife and daughter's house and then I FaceTime with him up there. Yeah.
How often do they FaceTime with him?
Every day.
Every day?
Yeah.
Okay. Now, you said, you know, obviously we've gone over how he was acting the day before this
Mhm.
all happened, the day of. Since you FaceTime with him, since he's been in jail, what, close to 2 years now, right?
Yeah.
Have you noticed any of those paranoid type of behaviors at all? Does he seem like he's pretty much back to baseline
He seems pretty,
even?
yeah, now. It looks really bad, but I mean, he acts kind of calm now.
So he looks bad?
He looks bad, but it's really, he seems like he's calm now. He's not in the state he was in like this.
Fair enough. Judge, I think that's all I have for now.
Any cross?
Yes, Your Honor, I just have a few questions for you, Ms. Stines. Let me make sure I understand this right. So Mickey wasn't acting right the day before to the point where you were concerned.
Yeah, he was acting, he was,
And did you call anybody?
no,
Did you call his wife and say, what's wrong with Mickey? Something's wrong with him?
no, he was,
And the next morning when you got this phone call, you didn't call anybody, you didn't call anybody at the sheriff's department, did you? And say, hey, something's wrong with Mickey, is he there?
no,
Did you? And you didn't call his wife that day either, did you? And say, Mickey's not acting right, he asked about bones, is something going on with Mickey? You didn't call her either, did you?
no. When he called and asked for my mother,
Yes, ma'am.
that was right before it happened, so I didn't
Yeah.
have time to call
I
anybody.
think you said you had 30 minutes before you realized what had happened. So in that 30-minute window before you realized what happened, you didn't call anybody, did you?
It had already happened.
Right, but you didn't know that.
No,
Okay, so you never called anybody between that
Sure
time and
didn't.
the time you found out.
no.
And you've spoken very highly of Mr. Stines, but my understanding is that he's concerned for his wife and daughter. Is that right?
Mm-hmm.
And he left them at home alone. Went to your house. Is that what you're saying?
Mm-hmm.
He didn't stay in the driveway. I mean, they were upset because he's walking around and keeping them up. He didn't go to the driveway and sit in the car, did he?
I don't know if he did that or not.
He left and went to your house, correct?
Yeah, he did come to my house, but I don't know what he did before that.
Okay. And what time did you say he showed up at your house?
I don't know exactly. I didn't think it was going to be important at the time, so at the time I didn't notice.
Now, I think most people at this point in time, you've been a resident of Letcher County your entire life, haven't you?
Yeah,
And I assume you've seen this video also, haven't you?
what video?
The video in Judge Mullins' chambers.
Yeah, just once, part of it, yeah.
And you know who Kevin Mullins is? don't you?
Yeah, I know Kevin.
He's district judge?
I know Kevin.
He's a district judge, correct?
Yeah.
Was a district judge,
Yeah.
is a better way to put it. And you saw
I
the
saw,
shooting?
yes.
That's all I know.
Thank you, ma'am.
But Judge, briefly,
Sure.
when Mickey came to your house, you knew that he'd been to the doctor that day.
Yeah,
Okay. And you knew that there'd been some concerns about his mental health,
yes,
and that was the reason he was taken to the doctor.
yeah.
And when he was at your house, he kept the cameras on at his house all night long.
Watching his house.
Did he ever turn them off?
No.
Did they keep you up at night?
I could hear the little crickets and jar flies all night.
And was he concerned the entire time about what was going on with
Yes,
his
he
life? and
was.
health?
Yes,
So I'll
he was.
have to.
Nothing more here.
All right, thank you, ma'am. You may have a seat. Any other witnesses?
Judge, I have a pretrial officer that interviewed Mr. Stines prepared to testify, but if the court can take judicial notice of its own report, then that won't be necessary. We can release that witness.
Sure. that'd be
No,
fine.
no objection to the court, Judge.
All right.
That's all the witness.
Anything from the Commonwealth?
Nothing, Your Honor.
All right. Ms. Bartley, any argument?
Your Honor, I will ask the court, understand the court's ruling in the order, I believe in December, regarding the report from Dr. Allen.
Yeah,
I
and I
will,
will take that under consideration.
Yes, Your Honor.
That is,
yes, Your Honor, thank you. That's absolutely an issue that we want to make sure we preserve. Judge, in terms of argument, it's the Commonwealth's burden to establish that the proof of Mr. Stines' guilt of a capital offense is evident, or the presumption of his guilt of a capital offense is great. Now, the cases say, and again, Markham v. Broughton sets the standard that says where conflicting evidence creates a plausible basis for self-protection, or the reduction of the offense to a non-capital degree, the Commonwealth has failed to meet its burden, and he's entitled to bail. Judge, the Commonwealth here, the only proof they've put forth is a video. And while I agree it's a compelling video, it absolutely is compelling evidence, Your Honor. Understand that. But the only thing that the video shows is an act and an identity. We don't have any element of intent. And the murder statute, Your Honor, anticipates, it actually makes an element, EED. EED is an element, or the absence of EED is an element, right? So they have failed, Your Honor, to put forth any proof as to the mental state, any premeditation, anything to that effect that would be necessary to take that and make it an aggravated capital offense. And our evidence, Judge, while it's been brief, we have Ms. Stines, we have the court taking judicial notice of certain pieces of evidence of the pretrial report. I believe that that creates enough of a presumption, Judge, or enough of a plausible basis, which is the standard under the law, to show that Mr. Stines acted in such a way that a jury could believe that he was either operating under extreme emotional disturbance or potentially even insanity. And I understand the court's ruling, again, on the insanity argument, right? That, you know, that's an affirmative defense, that's for trial, we're not having a mini trial here today on whether he is insane, whether he had the requisite mental state. But all of that proof, or the absence thereof, goes to whether or not he's bailable, and that's the only thing that we're looking at today. Did their proof meet that burden? Now, I think evidence put forth by our single witness, Judge, and then of course what the court is going to take notice of, demonstrates that there is a plausible basis that this comes out of the capital murder arena. think, evidence that he was, Ms. Stines testified that he was acting out of his character, that he was paranoid, that he was having concerns about the safety of his wife and daughter. And the standard for EED, as the court knows, is it's not an objective standard. It's not a reasonableness standard, what a reasonable person would think. It's what he thought. What did Mickey Stines think was happening at that time? Why was he in fear? Why did he believe that his wife and daughter were in danger? And he clearly did. Now, the Commonwealth makes much of the fact that he left his house and he was at his aunt's house, but I don't think all that matters when you look at the mental state that he had at the time. He was completely out of his typical character. And, the court will take a look at that video, and again, it's compelling, but I think there's so much more, Judge. And although the court, again, said that, insanity is not necessarily relevant at this stage, the cases that we look at, there are several cases that say that bail should have been granted in a capitally charged case. And I think it is relevant that the Commonwealth hasn't filed a notice at this point, right? So RCR, I believe, 402 says that.
Well, as we discussed earlier, that's being held in advance at this point because there's outstanding issues in regards to that.
Sure, Your Honor. What I'm saying, Judge, is that.
Let me ask you this, Ms. Parker, because I do want to kind of move things along.
Yeah,
a little
absolutely.
bit. What is the bond you're proposing?
Judge, what we requested previously was $50,000 cash or property, Judge, with any conditions that the court deems appropriate. The court has heard all of the proof on, he'll have a place to stay, he's not a flight risk, he has no criminal record. He, in terms of the pretrial risk assessment, he's a low 0, the lowest that he can be. There's no reason to think that he wouldn't be compliant, he wouldn't reappear. There's no reason to think that he would reoffend, Judge. So we would ask for that, but with conditions. I think there are sufficient conditions to ensure his appearance, sufficient conditions to keep him and the community safe. An ankle monitor would be appropriate, Judge. No movement, GPS monitoring if necessary, no firearms, clearly. I think the court can fashion any number of remedies to allow him to be out in the community and prepare his defense outside of the confines of the Leslie County Jail. And so we would ask for that same bond, Your Honor, but of course, whatever the court deems appropriate, I'm just asking the court to find that he is in fact available and to set a reasonable bond.
All right, Mr. Steele.
Yes, Your Honor, I'm going to point everything she mentioned regarding insanity, those are all defenses, every one of them. We're not here for that at this point in time, but in regards to the bond, I'm going to point to the court direction of Commonwealth v. Jones. I believe I got the court the last time. It's 2024 Westlaw 2982769. And in that case, out of Breckenridge County, the Commonwealth chose not to seek that. And at that point in time, the circuit judge says that I'm going to grant a bond. There's a long analysis of that in regards to Criminal Rule 4.02. 4.021 says everybody is entitled to a bond except those charged with a capital offense. And the conclusion, I'll read the conclusion in the last chapter. Jones was charged with a capital offense, which death was a possible penalty. Per Kentucky Constitution, Section 16, we believe it is incumbent upon the circuit court to make an express finding as to whether the proof of Jones' guilt is evident or the presumption is great. One or the other. Accordingly, we reverse the orders of Breckenridge Circuit Court granting bond and setting conditions of release and remain the matter for determination of whether the proof of Jones' guilt is evident and the presumption is great. If the court answers the question in the affirmative, then Jones is not bailable. The evidence is that Judge Mullins was a public official, which would make this a capital offense. So we do not believe he is a bailable defendant based upon the charges.
All right.
Your Honor, if I may just respond to that briefly. Jones, Your Honor, as the court knows, and cited in its order that was dismissed as moot. I don't think the court ever reached the ultimate question, so it's still an unsettled matter of law. But the analysis is the same,
Sure.
Judge. So I don't think that case is really relevant at all to the court's analysis.
All right. I will get an order out on bond. I am going to be real honest. The thought of a $50,000 cash or property bond is something the court would not entertain. If the court does believe that he is bailable, this would be a bond that would be much more significant than that, but I'm gonna hold that in advance and get an order out to you all in regards to that.
Yes, Your Honor.
Next, we've got a petition for change of venue.
Yes, Your Honor. So that is the Commonwealth's motion. We have attached 3 affidavits to that also. We've laid out the law for the case. I'm not going to go further. There was an attachment also, I believe, to the original motion showing also the news coverage, not just locally, but also nationally. I did just a little searching yesterday and updated some numbers. It appears the Mountain Eagle, which is the local newspaper for Letcher County, has had, at this point in time, had 103 articles written on this. They have a Facebook page, over 30,000 members on their Facebook page. I believe of the 103, I believe the number I got was 20 of those were speak your peace articles, in which people can just can say whatever they want to anonymously. And then there's comment, as you can imagine, in every direction. This was the top story in 2024 on both the Mountain Eagle website and on the Mountain Eagle Facebook page. WYT News, a local, I'm going to say southeastern Kentucky, has had 33 articles, news coverage in the last 12 months, I believe it is what I showed. Judge, and I'm not going to say what people say because obviously I'm being quoted.
Sure.
But suffice it to say, a large number of the community has strong feelings one way or the other. And it's just not in Letcher County. I was had a conversation with Victim's family in Perry County just 2 weeks ago. And of course it came up. And he was very strong with his opinions as to what it was. Not just based on news stories, but based on just rumors and word of mouth and some outlets that, I didn't get into the YouTube bloggers, which has been insanity, to say the least, in regards to theories and things they are saying out there. I believe defense counsels even commented on some issues as not being true that have come out in those. It's our position, Judge, that the news media coverage in southeastern Kentucky and even central Kentucky, because the IMT they're a sister station to a Lexington channel, the coverage has just been unbelievable. I could go into Facebook pages all over southeastern Kentucky and find strong opinions. The market changes when you get in western Kentucky in regards to where their news has where they receive their news. You really receive news out of the Nashville network and not the Lexington or South Kentucky network. So that's our position, Judge. The affidavits are of a practicing attorney, of the Commonwealth attorney, and the county attorney. To be honest with you, the county clerk and the circuit clerk weren't available the days I was over there. I think they realized what was on the docket and they both got out of town. So those are the people that I could catch up with. I can tell you I could get these signed by almost anybody in Letcher County. And these individuals that ran for office have a finger on the pulse.
Thank you, Steve. All right, counsel?
Yes, sir. Judge, we had subpoenaed the people that had signed the affidavits for the change of venue, and I think one of them is Miss Ashley Fields.
Okay.
If I could call her.
Sure.
Is Ashley Fields here?
Yes, sir.
Thank you.
Ma'am, if you would raise your right hand and sworn, do you swear from the testimony you give me the truth, whole truth, nothing but the truth?
Yes, I do.
Please state and spell your name.
Ashley Sturgill, ASHLEY STURGELL.
Counsel,
Oh, I'm sorry, Mr. Clerk, I thought it was Fields. I don't know where I got that from.
I'm married, but I did not change my name.
Good. And you state your name correctly. Where do you live?
I live in Whitesburg in Letcher County.
And is that like, do you live in the community, or do you live in town there? Or,
In the community, in town.
what is your community's name?
I live in Whitesburg, in the upper bottom there.
Okay. And have you lived there all your life?
No,
How long have you lived there?
I've lived there for approximately 3 years.
3 years.
Yes.
Now, let me ask you, What, do you work anywhere around the courthouse or do anything like that?
I'm an attorney in town,
Okay, and what kind of law do you practice?
general practice.
Okay. And did you happen to be in the courthouse the day of this occurrence?
I did, yes.
And so you could technically be kind of a witness.
Yes, that's
Would that be
correct.
right?
Yes.
And did you have any emotional feelings about this?
I was there that day, so I think,
Did it shake you up?
of course,
Okay.
yes.
And so when would you have moved to Whitesburg there?
I think I moved in the fall of 2022.
Okay. So you lived there approximately 2 years, would that be right, at the time of this occurrence?
Yes.
Okay, in that same place?
Different places in town. I've lived several places.
Oh,
in
okay.
Whitesburg.
Let me ask you, you state in your affidavit there that in support of this motion to change the venue, let me ask you, what public opinion? How many people are in a public opinion?
I think it refers to the state of public opinion.
Well, that's what I'm asking. Let
Yeah.
me show you what you signed.
I've got a copy of it,
Okay.
sir.
Well, I just wanted to know, how much?
I've worked in the community there for about 8 years now.
Oh, okay.
Yeah.
All right. And tell me something. Do you practice any criminal defense, anything like that?
Yes.
So you understand, when you said that the Commonwealth couldn't get a fair trial, is that right? That you said even they couldn't?
I think I said both.
Both
neither
parties,
party
well,
can get a
neither
fair
party
trial.
could get a fair trial. I'm just going to talk about the Commonwealth.
Yeah.
You understand it as a criminal defense, somebody that does that, that you start off with a presumption of innocence in every criminal case.
Yes.
Presumption of innocence. So already the Commonwealth has got a burden to go over to overcome that presumption of innocence. Is that right?
That's correct.
Okay. And what is what to you is a fair trial for him, Mickey Stein?
Again, I don't believe either party could get a fair trial in a community where that you have a victim and a defendant who were both elected public officials in
Well,
that community, which inherently brings with it a lot of love and a lot of hate and strong opinions toward either.
Okay, but I'm just saying, in a trial, could you understand why a person would want to be tried in their home county?
I can see why people would want to, but I
Okay.
can't see why anyone would want to in this
And
situation.
in this public opinion that you talk about, have people expressed to you that no matter what we hear in that case, in that trial, we're never going to believe anything the Commonwealth has to say?
Excuse me, can you repeat that?
Has any of those people that you said have public opinion,
Mhm.
has any of them expressed to you that no matter what is said in the trial, I'm not going to believe anything the Commonwealth puts forward?
There are people who have taken strong stances on either side,
But
very publicly. Now, do I think that someone would come in and admit some sort of inherent bias? No, I don't think that people even realize that they have that usually.
Mhm.
I don't think someone would walk in here in front of all these people and admit to being racist, for example.
Okay, race isn't an issue in this case.
I know, but I'm just
Okay.
saying, those types of inherent biases, I don't think people would be willing to just freely admit to that.
True, but that's in any case you try, no matter what kind of case it is.
Correct, where there's some sort of bias.
There may be a bias about anything. True. And all that the court can do is ask, all we can do is ask questions and go by the answers that the people give, right?
Correct.
And you're not here saying that the Letcher County people would give false information under oath about on board there, are you?
No,
Oh, okay.
what I've just said is that, and I'll repeat that, I think that most of the time when people take strong stances, they don't even realize the bias that they actually have.
I understand. But no matter what, he's presumed innocent.
Correct,
He starts off right there.
correct.
So there's a bias there. Isn't that kind of a bias that if he has to start off being presumed innocent?
A presumption?
Presumption of innocence, yes ma'am.
I don't know that I would consider that a bias.
Okay. And let me ask you, did anybody ever express that no matter what the Commonwealth put forward, we don't believe it and we're not going to pay any attention to it?
I think people have expressed that in other words. Yes,
What-
people have continued to, even locally, to have opinions and very publicly and support certain rumors, which I think Mr. Steele hit on, that even the defendant's own counsel have now said on numerous occasions are not true. So, yes, that's
Now-
the answer to that.
Okay, let me ask you something. I'm just curious again, I'm just wondering, how many people have you expressed this opinion, or how many people are you saying are in a public opinion?
Sir, too many that I could count over the last year and a
What's the
half.
population of
Several thousand.
Letcher County?
I think, I want to say, I don't know.
Okay.
I don't know the answer to that.
Yes,
Small community,
ma'am. And now you're just in private practice right now?
yes.
Were you ever the county attorney or in the county attorney's office?
No.
Okay, that is fine.
Yes.
Okay. Did you know any of these other folks here, Mr. Matt Butler? Did you know him, by any chance?
Yes, I know him.
And do you know Mr. Holland, or is that his name? Howard, I'm sorry.
Mr. Hatton?
Yeah, Hatton,
Yes.
that's it, yes.
Yes, I'm familiar with both of them.
Okay, and that's people you've talked to about this too?
I talk to them regularly.
Okay.
Um,
All right.
through work. We work together.
And who asked you to fill out an affidavit?
The affidavit that I signed was presented to me by Mr. Steele.
Thank you, that's all.
Sir, I've got a few questions. My role's a little different than Mr. Cox's, and he's worried about his client. I'm worried about justice on both sides. And he's just concentrated on the Commonwealth not getting a fair trial. Does he say Mickey Stein has a presumption of innocence, right?
Yes.
Is it your position that if he was to be tried in Letcher County, that Mickey Stein would not have that presumption when he walked in the courtroom in front of a jury peer?
I don't.
Objection, Judge. Objection. Can we approach the bench here?
Sure.
Or would you rather?
I'm sorry, could you repeat it?
Is it your opinion, after talking to people, and we're gonna get into that just a little bit, that Mr. Stines would not have preponderance of evidence when he walked in on that first day of trial. Presumption of innocence, I'm sorry, presumption of innocence.
I think that it would be hard to there.
And is that, you kind of talked about this, is that because of the mindset of people either for or against him?
Yes,
And you do criminal defense, correct?
yes.
How many times have you had criminal cases that have had over 103 articles written on it in the Letcher County paper?
I have not had one yet.
Okay. You've had voir dire,
Yes.
talked about voir dire. That's one of the issues you go over, isn't it?
Yes.
Is media coverage.
Yes,
You said you're in general practice.
yes.
How many, of course, most people don't understand, but just walking in and out of courthouse, people talk to you on a regular occasion, just pull you out, hey, I need to ask you a question?
Of course, yes.
So how many people, I'm not asking you to guess, but just give us an, how many people do you think you talk to on average in a week in Letcher County?
Oh. I couldn't say. I would say,
I couldn't either.
yeah, I
That's
don't,
kind of
it's a
fact
lot.
question. Sure.
Too many for me to remember on
How
a daily
long have you
basis.
lived in Letcher County?
I've actually lived there since the fall of 2022, but I've worked there in practice since 2019 in the summer.
Okay. So you are familiar with the community.
Yes,
You obviously know quite a few people in the community now.
yes,
Is that just in Wattsburg, or is that in different areas, other communities you know people?
all over the county in different areas.
Okay. And I'm just curious, how many times does the conversation turn to this case? And just a general, everybody getting together, sitting around talking, how often does this case come up?
Very often, unfortunately.
When you're talking to people, and I'm more, not talking about the people in the courthouse, the people out in the community that you say you know, is it your position that they have strong feelings as to innocence or guilt, one way or the other?
Yes,
Is it fair to say that there are rumors going around in the community
yes,
that people do believe, regardless of what's been said, that the Commonwealth would not get a fair trial? That people have said, and I've read it, I'm sure you have, and I hate to quote people on the internet, but people in the community that said he should be free.
yes.
What he did, he should be free. I think I read the one, he should be given a key to the city or something like that. Have you heard those type of comments?
I've seen them and heard them, yes.
And those are from people in Letcher County,
Yes, those,
all of the age of being on a jury panel.
yes, they appear to be adults on Facebook and various social media platforms, yeah.
Now, when I see something on Facebook, I may not know who they are. I'm assuming when you see names on Facebook, like if I did in Laurel County or Knox County, I know some of those people. When you talk about these people that are saying things, are you talking about the unknowns, the anonymouses, or the people that like, oh, I know them, that represent their kid, or I did a will, I did. Are you talking about just the people you know that live and reside in Letcher County?
Yes, I've seen it from people that I know and or know of, and I've seen it from random people that I don't know. But I've definitely seen a lot of commentary that does appear to be people who are local, either taking one strong side or the
Or the
other.
other? And if this is very, would you say this has been very divisive in Letcher County?
Yes, absolutely.
That's all I have, Your Honor.
Any follow-ups?
Very few questions.
Sure.
If that's all right. Ma'am, how long have you practiced criminal defense?
Since 2019,
And was it just in Letcher County, or is it in other counties?
other counties as well.
Okay, you weren't by any chance a public defender, were you?
No.
Oh, okay. Because they practice in other counties too, but I just wanted. Let me ask you, how many changes of venue have you ever asked for?
I don't know.
Have you ever?
I don't know if I may have at one point, but I don't know.
Okay. Usually you ask for a change of venue because there's kind of a.
Are you talking just in a criminal case?
Yeah, criminal case, yeah.
I don't think I've asked for one in a criminal, in any of my criminal cases, but I have asked for it in other cases.
Okay. But like civil cases or something like that?
Yes.
And in your experience as a criminal, just in criminal defense, how many times has the Commonwealth asked to move one of your cases to another county?
None, not yet in my career, but I don't believe that's uncommon in high-profile cases.
Well, I understand that, but I mean, you've never had a case that the Commonwealth's ever asked for a change of venue?
No.
And let me ask you this, would you know if this case has been, I mean, where would it go if it was changed? Where in the world would it go? Because it sounds like it's just almost worldwide.
I am not the one in charge of that, so I don't know.
Yeah, I got you, but you can, what I understood you to say is that just massive amounts of publicity and talk, social media and all that other.
I don't think anyone in this room could deny that.
Okay. That's all.
Nothing further, Your Honor.
Ma'am, has there been anybody you've talked to in regards to this case that you don't believe has already formed or expressed an opinion on the guilt or innocence on this case?
Judge, I believe people have already formed their opinions.
On this case?
Yes.
You're in the courthouse every day, or not every day, but at least every week in Letcher County?
Yes.
In your opinion, in your conversations with the citizens in Letcher County, is there anybody you've talked to yet that hasn't expressed or formed an opinion on this case?
There have been people who, of course, they want to ask questions,
Sure.
but, no, I think that for the most part, I feel that for the majority, people have formed an opinion already.
All right, thank you.
Thank you.
Congratulations.
Thank you, Your Honor.
Any other witnesses?
Mr. Jamie Hatton?
Jamie Hatton? Sure.
Yes, sir.
All right, Mr. Hatton, if you would, please raise your right hand and be sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Please state and spell your name for the record.
Jamie Hatton, Jamie Hatton.
All right, thank you. You may ask
Thank you,
counsel.
Judge. And Mr. Hatton, where do you live?
Whitesboro.
And do you hold any position, elected position or anything like that?
Yes, I'm the Letcher County attorney.
Oh, okay. Who asked you to sign a petition for a change of venue?
Mr. Steele.
Okay. And as the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay. I didn't see you at the preliminary hearing, and I just didn't understand. All right.
I was
And-
Mr. Stines' attorney at the time of the commission of the offense, so.
You were?
I wasn't anymore.
I understand. And let me ask you, when you say community, how many people is there in Whitesboro?
About 7,000 people in the city limits, 20-some thousand in the county.
Okay. Now, you certainly hadn't talked to every one of them.
Nope.
Okay. How many you guess you talked to about this case?
To guess, hundreds, I would imagine.
Okay. And I know that, has anybody just said that I am going to not believe anything the Commonwealth says about this case?
No one said that. to
No
me.
one said.
Not to me.
Anybody said, no matter what's said, no matter what's done, I'm going to find Mickey Stines not guilty?
No one said that to me.
And you agree he has a presumption of innocence?
Sure.
Okay. So you're a prosecutor, right?
Yes, I've sat at this table and at that table as well.
Okay,
throughout my
okay, I
career.
got you.
Sure.
And what is a fair trial for the Commonwealth? What does that mean? If he has a presumption of innocence, you already start with something right off the bat.
I think fair is subject to the eye of the beholder, you know. What's fair mean to you?
Well, that's a good question. But I was just going to ask you this. Would it be important, do you think, now Mr. Stines hadn't asked for a change of venue, do you think it's just about equally as important that he be allowed to stay in his own county and place his trust in the people of Letcher County to judge his case?
Sure.
You think they can?
Think who can?
You think the people of Letcher County can judge his case fairly?
I mean, I've got a great respect for the people of Letcher County, but I couldn't imagine, you would almost have to have 20,000 jurors in there to try to find 14. You know what I mean? They don't have really strong opinions.
I understand what you mean.
Yeah.
But, I mean, do you understand, should a person be able to be, those people put their trust into Mr. Stines when they elected him. Mr. Stines put his trust in them. Do you understand it would be important to him to be tried in his own county?
Yes.
And they would be fair.
I don't know if they could be or not, honestly.
Okay. Would they be honest and say, no, I can't be fair?
How could you say?
Gotcha.
You've done a lot of voir dire.
Yeah.
I mean, we're honest with you.
I understand.
You know.
That's a chance we have to take.
Sure.
Judge, that's all I have.
Just a few questions, Your Honor. Debbie, how long have you been county attorney?
15 and a half years now. We're halfway through this year. Yeah.
So, you obviously politicked a lot in Letcher County, and know a lot of people in the community.
Yes, sir.
How long have you resided in Letcher County?
Other than the 8 years I was off to school, all of them.
Or even when you was at school, your mom and dad lived there?
Absolutely.
Families from Letcher County?
Yes.
Have roots going back to Letcher County, all over Letcher County, don't you?
Yes, indeed.
And again, is there people in your community that you, and how many, as a county attorney, I don't even want to fathom, how many people you talk to in a week?
I would say, you mean just in my work?
Just
or
in general,
going to
yeah, not counting family, but just people walk on the street, people calling the office, people wanting to visit your office.
Probably 100 or more weekly, sure.
And you have a private practice also, don't you?
Yes.
And so you deal with car wrecks and other litigation, other than just criminal prosecution. So you have
True.
clients, not just from the criminal world, not just officers coming in, but you have other clients coming in for wills and estates and all that, those probates.
Yes, that's true.
How often does conversation turn to this case?
Well, for the first probably year after it happened, pretty much the first time I'd see someone, and talk to them, they want to talk about that.
Well, because you're the county attorney.
Sure, yeah. And then whenever I'm in court, anywhere else in the Commonwealth, that's the first thing. Oh, you're from Letcher County. They want to talk about this case. So,
Okay.
yeah.
So it comes up frequently.
Yes.
Not as much today, I guess, as it did the first year, you said. In those conversations, just talking about the people of Letcher County, not in other counties, we're talking about other attorneys, because they're always inquisitive. When you're talking to just people in Letcher County at ball games or cookouts or fire department raffles, whatever, how often does this still come up?
Really, every time a hearing or something like this comes before the court, it pops right back up to the conversation of the day, and then it'll fade into the background and come back.
When that next article comes up, there goes again.
That's it.
Do you subscribe to the, and I hate to put you on the spot, do you subscribe to the local newspaper?
Yes, I do.
And have you seen articles on this?
Oh, yeah, lots of them.
Do you also check their website, read articles on the website?
I used to more. Now that I've got the subscription, I just read in the paper for the most part.
Can you tell us, if you're familiar with, what is the Speak Your Piece?
It is a sort of it's really cool, but it's a local opinion thing. Anyone, anywhere can call in and leave a message, and they'll post it in the newspaper. Yeah.
And then they're on the website.
We'll post it in the newspaper.
We publish it in the newspaper. It has a whole section. Yeah.
You can call in anonymously,
Yes.
leave a voicemail, and publish it in the newspaper.
That's correct.
And in regards to online, you can actually make comments to that, can't you? Have you seen that? Are you aware of that?
No, I've never seen Speak Your Piece online.
Okay, fair enough. And I want to ask you more on that one. Jamie, in regards to the hundreds, thousands of people you've talked to in the community in the 2 years, almost 2 years since it's come about, what do you think the percentages are of people that have made their mind up or have very strong opinions one way or the other?
I couldn't say a percentage, Mr. Steele. It just seems like there's a very strong Team Mickey, and there's a very strong Team Judge Mullins. And lots of people tend to fall on one team or the other.
And I think you even said you'd have to have 20,000 people, you get 14 that's gonna fall in the middle.
Yeah, yeah,
Um,
it'd be tough.
Let me ask you, Jamie, in regards to team, you said Team Mickey and Team Judge Mullins, are they pretty rooted in their position?
Seem to be, you know, they really do. They seem to be from the start, from the outset. People started teaming up, it felt like, you know.
And as a county attorney, and as a public defender, do you see change of venue as appropriate in this matter, based on your understanding of not only the people of Letcher County, but also of the rule of law?
Yes, that is my opinion, just for judicial economy, for one thing. We can bring the circus back to town and try and do this, and just, you'll just end up having to go to another venue eventually, however many times you want to set it for trial in Letcher County. It just doesn't seem feasible.
And you've been through the four dire process, picking a jury multiple times in Letcher County Township.
Yes, I have.
That's all I have, John.
All right. Any follow-up?
Just a few follow-ups.
Sure.
Mr. Haddon, I heard that you had been not only county attorney for 15 years, been a public defender.
Yes.
How many times did you file for a change of venue?
Never.
Never. So you didn't have any high-profile cases or any cases you ever worried about?
Nothing like this. Nothing like this.
All right.
No, not even close.
And how many times have you ever seen that the Commonwealth filed for a change of venue?
It's the first time I've seen it.
And I think you said whenever you go out of the county especially, people ask you, and then when they find out you're from Letcher,
Yeah.
is that because you're with the county attorney's office, or just, I'm a citizen of Letcher County?
I don't know.
Don't know.
You'd have to ask them.
Okay, I got it. And can you see, no matter what, I know you said that this could be a terrible situation, but did you ever know of any cases that were real high profile that they tried them right there in that county that it happened? No matter how high profile.
I would imagine this is the highest profile case in the history of our little county.
Yes,
Yeah.
yes, but I'm just saying high profile cases. Did you ever hear of that case in Pulaski County where the sheriff got assassinated?
No.
Okay.
Withdraw.
That's fine. Nah, that's all. That's all.
Any follow-up?
Nothing further,
All
John.
right, thank you, sir. You're released from your speech.
May I
Yes,
leave?
sir.
Thank you, John.
Judge, if you'll permit me, I'd like to call out the name of just one more person to make sure they're not here, and that would be Mr. Matthew Butler.
Is Matthew Butler in the courtroom?
Could we approach a bench on that matter?
service?
I have no service on my cell phone
Okay.
at all.
Uh,
I had to walk about.
We'll provide your phone back in the back and just
Okay.
try to find it. All right, ladies and gentlemen, we're gonna be in recess for a few minutes. And we will, start the docket back in just now. All right, can you hear me okay? All right, counsel, you can approach and question at the bench. All right, sir, if you will, please state your name for the record.
Matt Butler.
All right, Mr. Butler, your first going to be a question on counsel on behalf of Mr. Stines. Go ahead.
Mr. Butler, would you state your full name
Matt Butler.
and what position do you hold in Letcher
I'm
County?
the Commonwealth.
I'm sorry?
Go ahead with the question.
I'm just going to ask, what position do you hold in Letcher County?
I'm the Commonwealth Attorney.
And how long have you been Commonwealth Attorney?
July 1st of 2024.
Mr. Butler, I guess I got to ask you, you know, we tried pretty hard.
We don't need to discuss
All
the
right.
subpoena issue. Ask your question.
Okay. Let me ask you, you signed an affidavit. Who asked you to sign an affidavit for a change of venue?
I believe that was the Commonwealth.
Okay. And how many changes of venue, as you as a prosecutor, have you asked for?
None.
So you don't have, as you sit here today, you don't have any issue with the, I guess, fairness or the ability to trust the Letcher County juries, do you?
I don't understand the question.
Well, do you have, as you sit here today, do you have any trouble in relying on the truthfulness and the fairness of the Letcher County jurors?
The question of whether or not Mr. Stines can receive a fair trial and whether the Commonwealth can have a fair trial is based specifically on that case. It is a case-by-case approach. If there were a case where a defendant could not have a fair trial and the defense wanted to move it, I would not object to that. If the Commonwealth could not receive a fair trial in a case, I would move to change venue on behalf of the Commonwealth. But it's a case-by-case approach. This case is unlike any other that has happened, to my knowledge, ever in Letcher Circuit Court, but certainly in the time that I've been the Commonwealth Attorney.
All right. Can you tell me what exactly is a fair trial for the Commonwealth?
A fair trial for the Commonwealth would be one where the Commonwealth feels like they have just as much of a shot of getting an unbiased jury as the defense does.
Okay. And if the jurors could said that they could follow the judge's instructions and follow the law, would there be any problem with that jury?
You're asking about whether or not that could happen at the time you're picking a jury in Letcher County. And my affidavit supports my opinion that you couldn't even get to that place, that there is no way to seat a jury in Letcher County, Kentucky on this matter.
Is that based on your personal talking with people or just on like the coverage?
I live in Letcher County, and I've seen the concerted effort by you, your investigator, and others to paint the jury pool, and I feel that it is extremely unfair that you have taken great steps to imply that there's some sort of conspiracy that there's not, and the Letcher County jury could not see this matter. Also, the victim, the murder victim, was an elected official, and the sheriff was an elected official.
Okay. Now, let me ask you something. You didn't, Mr. Steele is the prosecutor in this case. Did you just voluntarily withdraw to get off this case?
Within about an hour of finding out that your client had killed our district judge, I had spoken with the Attorney General's office, and they had reached the same obvious conclusion that I was, that it would be better for a prosecutor from outside of Letcher County to sit in this matter.
All right. Good.
Sure. 1 second, please, sir.
Mr. Butler, I'm back. Were you ever related to Mr. Mullins?
At one point in time, from December of 2014 until July of 2029, he and I were married to a pair of sisters. During that period of time, I did not practice in Letcher County.
Okay. All right. Thank you.
Mr. Steele.
No questions, Your Honor.
All right, Mr. Butler, thank you for your cooperation.
Thank you, Judge Coleman.
All right. All right, any other witnesses?
No, Your Honor.
All right. Anything else on behalf of the Commonwealth?
Nothing further from my counsel this issue, Your Honor.
All right. Any argument, counsel?
Judge, if I could read from the case, the mere fact that jurors may have heard, talked, or read about a case is not sufficient to sustain a motion for change of venue, absent of showing that the accounts of descriptions of the investigation of judicial proceedings have prejudiced the defendant. That comes from the case Commonwealth versus Ronnie Lee Bowling out of the Laurel Circuit Court. It's cited at 942 Southwest 2nd, 293. And the reason I'm citing that case, Judge, I was the attorney in that case. Very serious case. And at that time, that was back, of course, this decision wasn't done until 1997, and the actual offense itself didn't occur until it was much earlier, sort of earlier than that. And London was a small town, a pretty small town by then. It's grown some now. And I remember there was a lot of coverage. There was all kinds of talk, everything else. It was 2 robberies, 2 murders. And I moved for a change of venue for the defendant, and it wasn't granted. And believe me, there was a lot of talk, and yet we tried to get a jury, and they did. They got a jury in that case over my objection, but they did. They didn't grant the change of venue. And I would just ask the court maybe to look at that case, because when I asked for a change of venue, I was pretty much told that those things didn't matter much about reading about them, hearing about them, talking about them. And I think that's kind of the position they're in Letcher County. Now, I don't know why people are so concerned that maybe the Letcher County people couldn't be honest and fair, because they elected Mr. Stines. He put his trust in them, and they put their trust in him. And I think there's some position here where he should have the right to be tried in his own home county, where he feels comfortable and safe, and that he is around the people he knows. And again, I think from hearing from them, if it's that kind of a wide coverage, that was some kind of, there's so much to talk about, where could you go? And where would you feel more comfortable? I know for his witnesses, at least they would be more convenient to be closer to home there, and it would be easier for them to come to court. Now, as far as these cases being high profile, I lived in Pulaski County. Several years ago, we had a sheriff that was assassinated. The trial of that person occurred right there in Pulaski County. And that was high coverage because he was assassinated. I just don't think that at this point in time, until we try to get a jury, and I think that's been the result of most of the cases that I've seen, that unless you try, you have to try, and then if you can't, then it's probably more pertinent to do it at that time. But at this juncture, I don't think that's been enough. Just having 3 people that are they're related to either by blood or they were at one time. Mr. Butler was talking about that. But to have people that are, working in the courthouse, one of them was a witness, and Mr. Hatton, I think, he's the county attorney. I think that's kind of telling. And I also think that the people that testified, at least, have never had a situation where the Commonwealth asked for a change of venue. Now, I know this case may be unusual, but unusual isn't the test. And I would just ask the court to consider all of that and not change that at this time until we've at least tried to get a jury.
All right. Response, Mr.
Yes, Your Honor. Let me just say, Mr. Cox, I remember those cases. When I say this, I'm not poking, but Mr. Bowen was in 1989, killing at a gas station. Mr. Catron was in the early 90s. I think mid-90s was when Mr. Catron. Judge, me and Mr. Cox both know that was before the fabulous internet and the coverage of which we see today from bloggers and vloggers and YouTube, whatever. It is a much different reality of what we're dealing with today. I'd like to point out one of the things that's always struck me since we first got this case is that one of the admonishments that the judge gives a juror during the qualification is do not go by the scene of the crime and do your own investigation. This would require us to have a trial in the building of the crime. The video footage that we would show from the outside of the response, Mr. Stines leaving, is of the building where they're gonna walk in and out of every single day during this trial. So it's impractical, one, that they could not do that and not go by and look at the scene of the crime. The fact that these are both elected officials also cuts against their argument that it should be moved, Judge. And Mr. Hatton, who's ran for county attorney many times, almost 16 years in, has said it's very Team Stines or Team Judge. It's just drawn a line in the community that we do not have a reasonable chance of getting a jury pool out of Letcher County. I believe when the numbers come back in Letcher County, their population is going to be less than 20,000 people because of the flood they had there a few years ago. I believe the number was, and Ms. Pratt said, in the mid-20s, but I believe the number's going to come back less than 20,000 in the next census. So, and they're losing population every day. I think he stated very clearly we had to pull 20,000 people just to possibly get 14 to sit on the jury pool. This is from the county attorney who deals in these, and I can't imagine how many phone calls the county attorney gets. The reason I don't want that job is the amount of phone calls they're going to have to get in a day just from citizens on a daily basis. The case of Brewster, 568 Southwest 2nd, 235, I interpret Shepherd as requiring a change of venue when there's been prejudicial news coverage. It's undeniable. I think parties talked about the inaccuracy of some of these news reportings that are detrimental. These, obviously, the news occurred prior to trial, which that's why we're here today and not at trial. And the effect of such news coverage is reasonably likely to prevent a fair trial. And I believe every witness that we had affidavits signed said just couldn't get anybody that would sit and actually give a fair trial on this matter. So Commonwealth thinks that the elements for the change of venue has been met, and we would request such.
All right. In response?
The only thing is I'd say as far as prejudicial news coverage or any kind of coverage is based on like that video that you talked about. And that's not the end of the story though. And I think I believe that with the trend has been what I've seen in change of venue, you have to try. If in Pulaski County.
I don't think there's any case law that requires that.
It doesn't, but I can say this because of the trend of what they're saying, how much coverage it gets and this talking and talk and things like that. They sure got one in Pulaski, and that was an assassination of a sheriff.
And what year was that?
That was probably, and he may be right, mid-90s, I can't remember exactly.
I think it was 94.
But I think if I agree, that was pre-internet.
94.
But the internet itself is such a big unknown, how many people are on it, and where they're at, and this, that, and the other. I mean, we could just go on and on, but where else in the world are we going to go? So that's what I want to do.
Well, that'll be, if I do grant the petition, that'll be the court's decision. First of all, there's been a line of questioning. I don't think anybody's trying to question the honesty or fairness of the people of Letcher County. This is a unique situation, to say the least. I am, at the request of defense counsel, going to review the case law that they've brought up today and cited. But I can tell you the court is going to be hard-pressed not to grant this petition for change of venue. I cannot fathom the thought of reasonably being able to obtain a jury in Letcher County with the amount of coverage. I do believe the county attorney said, and I'd already kind of thought of that analogy, it seems very clear that you've got a very divisive situation where you have Team Stines and Team Mullins, and these are some retractable, irretractable positions that would make picking a jury in Letcher County all but impossible. But I'm going to withhold ruling. I'll issue a written ruling after reviewing the case law cited by the defense, as well as the Commonwealth, and get that ruling issued. Anything else we need to address today?
Yes, Your Honor.
Okay,
Your Honor, as to the second phase of that equation, Your Honor, of course, we would maintain our objection to their motion. But in the event the court grants the motion, Your Honor, then I believe the parties should have an opportunity to address, I think the statute talks about the preference being adjoining counties, first within the circuit, and then, Your Honor, so I understand it's the court's decision, obviously, but I do believe that the statute would require that we do have input as to the locale and be able to present evidence to the proposed location, Your Honor.
well, and if I do grant the petition for change of venue, we can, I'll allow filings and requests and anything you'll wish to be heard on a potential location.
Yes, Your Honor, I just would,
I don't think, but like I said, it's not gonna head to an adjacent county. I mean, realistically, if the court does grant the petition, I think we're gonna need to be far away enough where the direct media coverage is not, as focused as it's been in this part of the state, so.
Your Honor, as to that second equation, I mean, I understand, Your Honor, but I believe the analysis is a county to which there is no objection, Your Honor, on the second part of the analysis.
Right, but it also requires it to be in the most convenient county in which a fair trial can be had. My review, I've participated in change of venue cases, and in my review of the law that's been promulgated by the Supreme Court, there is wide discretion vested within the circuit court on picking that final destination. So
Yes, Your Honor.
we'll address that at the appropriate time. All right, anything else today?
Looking for the call, Your Honor.
Mr. Bartley, anything else on behalf of Mr. Stines?
No, Your Honor.
All right, the court will issue written findings and rulings in regards to all the matters that were heard today. I am going to contact the parties by email to start looking at some scheduling timelines about getting this matter set for trial. I'll follow up with that, and then once the rulings are issued, we'll get a date set for any other additional outstanding matters. If there's nothing else to be heard, court will be in recess until the court orders further proceedings.
Sure, cash like